Good morning, good afternoon, or good evening. On behalf of the Department of Law, North South University, it is my utmost pleasure to invite you to this evening's webinar. We have our guest, Professor Frédéric Mégret from McGill University's Law School. He will be talking on conceptualizing diaspora in transnational law. I think we are very lucky to have Professor Mégret speak on this because he is working on a book project on this particular topic. And with my limited interaction with this course and also as a student of public international law, I think this is an area of law which has received very scant attention of international lawyers. People have essentially looked at the plight of refugees and others. But the old classic idea of the treatment of aliens, in my understanding, is not of that same degree of concern as it used to be. And more importantly, as I understand it, Professor Mégret and his co-authors, the way they are exploring this question in this book is thorough and is quite, I would say, innovative in the sense that it would stand apart from the existing literature on the very particular area. I think they are exploring not just the question of what international law does to the diaspora, but the other way around, that what does the diaspora do to international law? And I think some political thinkers, some constitutional law scholars, they have sometimes looked at these questions in various ways. But the mainstream public international lawyers, to my limited knowledge, have not really addressed these questions in a great deal. And if we look at the contemporary world, I think this is a very important issue. People are moving from one country to another at a much greater pace, at a much greater number, and that movement of people in various ways are posing new questions. So I'm quite sure this would be a fascinating talk. And I am sure Professor Mégret would have something very interesting to say. I look forward to Professor Mégret's presentation and also to your questions, dear audience. Professor Mégret, over to you. Thank you.
So thank you very much, dear colleague, for the invitation and for the opportunity. I'm really delighted to be here virtually with you. I'm grateful for the technology, even though it has its limitations. It's allowing some of these events to proceed across time zones and borders, I think, in the true spirit of transnational law, which is a spirit of connecting minds around the world interested in similar issues. So the topic today, as Professor Islam suggested, is conceptualizing diasporas in international law. I might say conceptualizing diasporas in transnational law. And as you kindly mentioned, this is part of a book project with Cambridge University Press, with my co-author, my esteemed co-author, Larissa van den Herrik. And based on work that both of us have been doing on and off over the years, at some point we realized this was really a gap in the literature. And I think even more than that, that the sort of diasporas were not getting the attention and we're not being done justice to in international and transnational law. There was really something missing here in our understanding of how diasporas operate, and how they stand to be regulated by international law, but also how diasporas speak back to international law. That's really a constant in my work, the idea that the subject speaks back to the law that regulates it, right? And retroacts, as it were, on the law. So is not simply a passive recipient of the law, but is also constantly constituting it. So I'll try to be fairly quick today and broad brush, and I am, of course, very happy to answer more specific questions that you may have in the discussion. So very briefly, I mean, we need a kind of working definition. What is a diaspora? I think you all know what a diaspora is, but you can have a sort of fairly extended definition of a population, but it's scattered across regions separate from their geographic place of origin. It's important here to notice the geographic place of origin. Most of the time, it's going to be a country, but in some cases, think of the Black diaspora. It's not particularly a country as much as a continent. The Jewish diaspora obviously did not relate to a particular country or a particular state as we would understand it in public international law terms. And I include both expatriate nationals, so your nationals who live abroad, and of course, Bangladesh is a good example of a country that has a fairly significant proportion of its population that lives abroad, but also the broader diaspora. So what is sometimes referred to in the literature as ethnic kin. So people who are, descend, might be third or fourth generation Italian American or Indian Canadian. These are people who may long have lost their citizenship to the state of in the state of origin, but nonetheless retain significant ties to that place, which may have legal consequences, right? And one of our ideas is even after people have left, particularly in our current world, their ability to maintain legal connections to a place of origin is significant, whether they have economic interest in the state of origin, whether they vote or in the state of origin, or supports political movements there, etc. The back and forth is important, and I would emphasize also maybe a technological element which is relevant. A century ago, people emigrated once and for all. And very quickly, particularly in settler states in the Americas and Australia, they kind of became off the place to which they had emigrated, sometimes retaining only a very loose connection to the state of origin, simply because you could never go back, right? It was too expensive, it took too long, it was too risky. And I think that's changed, right? We now have several phenomena where technologically, so for example, there's a lot of return mobility. People go and work all their professional lives in a foreign country, but they retire in their country of origin. They've saved up money and they go back. And so there's an element of back and forth, right? And they retain both passports, right? And Canada became aware of it a few years ago when bizarrely during the war in Lebanon, operation, I can't remember what the name of the operation was now, but the Israeli bombings of southern Lebanon. They say, well, what's the connection with Canada? Where it turns out that there's a lot of Lebanese Canadians, right? These are people who were born in Lebanon, emigrated to Canada, acquired Canadian citizenship, then moved back for business, for personal reasons, for retirement to Lebanon, and then found themselves caught up in this war between Israel and Hezbollah in Lebanon. And so they made requests to the Canadian government to come and pick them up and rescue them at significant cost. But of course, this is what states do. And so one of the questions there was, well, is this the Canadian diaspora or is it the Lebanese diaspora, right? Are Lebanese Canadians, what's their country of origin once they've gone back to Lebanon from Canada? Okay, so the other technological phenomenon, apart from ease of travel, is I think media, right, and the kind of cultural infrastructure and the political infrastructure of diaspora. So it is the case nowadays, and I think we all know this firsthand, that you can live in a foreign country, but every morning wake up and watch your local news and catch the latest trend on YouTube back in your country, just by clicking on your computer, right? So you can inhabit two spaces. You live locally but you also live transnationally simultaneously. And that rupture, that tension between the local and the other place is, of course, very defining of what makes diasporas. So there's a few things that are worth noting at the outset for our purposes as lawyers. I think the first is that if you think of diasporas, you have to kind of switch the lens away from a dominant focus on immigration. I mean, everyone is talking about immigration, right? Because it's a hot topic right now. The whole debate, you know, asylum seeking and you know, irregular migration and the obligations of a host country, right? Let's say European country, Germany, you know, that is welcoming immigrants. Traditionally, there's been a lot less interest in the state of origin, right? Because I think the idea was, well, emigration is not that interesting. I mean, people just leave and that's it, right? And, you know, then they're no longer there. So they're of little interest to the law. And I think, you know, it's more complicated than that. We now have I think ought to have a broader understanding of emigration as an act that's never fully consumed, right? So you leave, but you never leave at the same time. You leave, but you retain your passport. And as I said, you go back, but even in the host country, you interact with your consulate, you interact with diplomatic services, and so, you know, you may continue to be subjected to taxation, you continue to be subjected to the laws of your country of origin, right? Let's say you married in Bangladesh and you emigrated to the UK, you're going to be subjected to Bangladeshi laws in case of divorce, right? Via conflicts of laws, etc. So, you know, what I think diasporas call us to do is to shift attention away a bit from the host country, the country of emigration, back to the country of emigration, okay? And so in the book, which is quite a big project, to be honest, and, you know, maybe we took on something too big for us, but we use all kinds of illustrations and examples. We're quite keen on a kind of socio-legal approach that really looks at law on the ground, right? And law as it's being experienced by diasporas, rather than, you know, adopt a kind of top-down, kind of stratospheric view of the law. Because, you know, our stance is, if you look at diasporas from international law from high above, you don't see diasporas. They're too anomalous. They're too quirky as actors. But if you look at the law from diasporas, then you very much see the impact that the law has on your daily life and how it structures that life and limits it, and, you know, also potentially creates opportunities. So we look at various examples. You know, they're written here. You've probably had a look at them. I mean, I think one of the things we try to do is, you know, include diaspora, sort of classic diaspora. So, you know, obviously the Jewish diaspora, which sort of gave its name to the concept. More recent immigrant diasporas that have, you know, attracted a lot of attention, you know, Filipino, Bangladeshi, Mexican, Nigerian, etc. But also neo-diasporic groups. The neo-diasporic groups are groups that may be living in a neighboring country. And so, you know, not necessarily economic migrants, but diasporas that were created by the shift of borders rather than by the movement of people, right? So think of, you know, when the Soviet Union broke down, that immediately created a Russian diaspora in you know, Russia's immediate periphery. Of course, we know this because we know it's part of a problem in eastern Ukraine and in Crimea, right? There are Hungarians that have been scattered throughout Central Europe outside the territory of Hungary since the Versailles Treaty, okay? So these are, I think, quite important, and one of our ambitions in this book is to treat them alongside the more traditional, you know, far-flung kind of diaspora. All right, so briefly give you a sense of the million little ways in which diasporas today create legal issues. And, you know, it's partly how you train your mind as lawyers to notice things that are typically not on a lot of people's radars, right? As international lawyers, particularly, I think we're quite guilty of constantly, making the law into a self-fulfilling prophecy, right? So if you say international law is about state relations, therefore I'm going to look at state relations, and as I'm looking at state relations, I get even more convinced that state relations between themselves are the central phenomenon of the international arena. Then, you know, there's a kind of feedback loop, right? I mean, I find what I set out to look. And if you're setting out to identify state practice and opinio juris, that's what you're going to find, right? But as we train our minds to see only certain things, we miss a range of other more discrete phenomena that may be just, if not more important, and particularly phenomena at the margin. And I think diasporas really fit that bill. Phenomena at the margin, but kind of are not supposed to happen, right? I mean, that are beyond the parameters of understanding of the discipline. So let me give you a very quickly, just to give you a sense of the richness of what's involved. Top left corner, Prime Minister Erdogan is conducting his re-election campaign. Now, Turkish citizens abroad can vote in Turkish elections, okay? So Erdogan, for the first time, decides that not only are Turkish citizens abroad going to vote, but he's actually going to go and campaign in the Netherlands, Denmark, and Germany, right? And so he, I mean, there's other example. Prime Minister Modi, was in Texas, meeting the Indian diaspora and trying to woo them and get their vote. So in the case of Erdogan, this is very interesting because the Dutch authorities didn't really know how to deal with it. And, partly their reaction was, well, another country can't organize, political rallies on our territory. What about, security issues? What about, and of course, politically, the subtext was, the Dutch and Danish governments are not particularly sympathetic to Erdogan, so they didn't really want him to rally the troops. But it raised many issues, and there were attempts to ban the meeting, etc. So you can imagine constitutional human rights issues arising. All right, just below that, repatriation of Indian citizens who lived in Ukraine at the outbreak of the war. Again, fairly classic international law stuff involving, the protection of one's citizens, but that clearly is dependent on a legal framework. But involves on one level the relationships of two sovereign states, India and Ukraine, but also possibly the rights of the Indian diaspora in Ukraine. What are their rights, right? What are the rights of African students who get stuck in Ukraine vis-a-vis their own government, vis-a-vis third states, right? So all kinds of legal issues bubbling just below the surface. Bottom left, the LTTE, right? So this is a Sri Lankan member of a diaspora in France, in Paris, has a store, and it surfaced to the Paris prosecutor that the LTTE was exacting a kind of, political tax or, engaged in racketeering operations, whatever, however you want to describe it. And so the police had to investigate a case of, a transnational criminal activity involving a non-state group vying for control of Sri Lanka and a part of the Sri Lankan diaspora. So new issues for the police. I can tell you they're not used to, this is a change from their local crime. Then moving to the right, the so-called, the top right, the Sharia debate in Canada, in Ontario specifically, about 15 years ago, there was a plan to have confessional or religious arbitration allowed under the civil law in Ontario. This created a huge debate at the time. Some people, so there was a kind of alliance between the Jewish and the Muslim diasporas in Ontario, both saying kind of together, well, why not, right? If members of our diaspora want to decide cases based on religious law, why should they be allowed to do it if there's consent on both sides? And then there were members of their diasporas saying, well, particularly women saying, well, no, we actually would rather Canadian law only applies. And then there were people in the general public in the host state in Canada arguing, well, this is the beginning of the end, it's fragmentation of law, it means there's a different legal system for every kind of diasporic community, where do we go from there? Then at the bottom, Fatima Begoun, the infamous jihadist, British girl who left when she was quite young, and you probably have followed this because she's a member, I guess, of the Bangladeshi diaspora, although she was, I think she's never set foot in Bangladesh and doesn't have citizenship, or arguably doesn't have citizenship, but the British government has been trying to strip her her British citizenship on the grounds that, well, she's really a member of the Bangladeshi diaspora. So that, you see issues of citizenship, withdrawal of citizenship, security, national security, diaspora, and, someone being caught in the crossfire with very little recourse. I'll go on very briefly because I could, list examples for forever, but then at the top, the protest against Saudi Arabia, we have a large Filipino diaspora in the Middle East that's often in a quite vulnerable situation. On several occasions, Filipinos have been sentenced by the Saudis, in some cases to the death penalty. That then creates a huge pressure back in the state of origin to protect their nationals, and again raises really interesting questions. What can the Philippines, what can Manila do with Riyadh in terms of pressing its case? Are there any obligations? I'll mention something very intriguing in passing. The Filipino government in Saudi Arabia, the embassy in Saudi Arabia has set up safe houses for basically Filipino home employees who've suffered sexual violence at the hands of their masters, right? So they're essentially creating safe houses, a kind of, welfare support system in a foreign country for their diaspora. And that goes beyond, merely providing consular services. That's really hands-on. You might then ask, what is Boris Johnson doing here? Well, Boris Johnson is a kind of what's sometimes being described as unwilling Americans or accidental Americans. So as you may know, the jus soli applies in the US. If you're born in the US, you become a US citizen. A lot of people were born in the US who then had very little connection to it. So it's my understanding that's the case of Boris Johnson. He was born, I believe, in New York, but then never lived in the US. Unbeknownst to him, he was still considered a US citizen by the US government. Unbeknownst to him, I'm not sure, but to make a long story short, and he was therefore eligible for huge tax bills upon selling real estate property, I believe, because the US, quite alone, but interestingly in the world, taxes its overseas citizens, right? Which raises fascinating constitutional questions, right? Is it fair that you should be taxed even though you don't live in the country? You're not benefiting from new roads or better investment in the infrastructure. You don't live there. Or maybe you are benefiting because you're benefiting indirectly from, US consular protection, US defense policy, etc. So, it's a really interesting question. Once you're gone, how long are you for how long are you part of a polity? For how long do you have obligation? At the bottom, Chinese students, I could come up with other examples. There's been a lot of discussion in Australia over the last decade of the influence of the Chinese Communist Party on Chinese students in Australia. And, you know, both in terms of a Chinese Communist Party monitoring and policing and disciplining, particularly pro-Hong Kong protests abroad by Chinese students, which raises questions for Australia, right? I mean, you're supposed to have freedom of expression, freedom of, you know, to demonstrate, etc. But what if a government is maybe keeping tabs on you and you know, punishing your family back at home for participating in these protests? And then we also have kind of pro Chinese Communist Party students who, for example, spy on other members of the diaspora, report back to the embassy about, you know, anti-Chinese activities, denounce a lecturer for using, you know, claiming, you know, using a map that shows Taiwan as a separate state, etc. So you have that kind of long arm of the state of origin, you know, with both a protective but also slightly ominous dimension. Two final examples. One is the kind of debacle in Australia a few years ago. Australia has Australia's constitution contains a prohibition on dual citizenship. You must only be a citizen of Australia to be a member of parliament, right? Not in general, but to be a member of parliament. And I think that rule had been enforced in a fairly lax way until a big scandal erupted a few years ago. And it turned out that I think about 14 members of parliament had double citizenship. Some of them were barely aware of it. You know, their parents had emigrated from Italy 50 years before, and they didn't realize that kind of technically entitled them or bequeathed on them Italian citizenship. So many had to resign, renounce their other nationality, and then, you know, go stand up for election again. Again, that raises really interesting questions. I mean, is that fair? How do we treat dual nationality in this day and age? Do we think that one cannot be a member of parliament and have a nationality of another country? You know, isn't that a bit narrow-minded, right, these days? But you can imagine, I mean, members of parliament are one thing. You know, another is, would we be comfortable with our prime minister or president or head of state being a dual national, right? I mean, there's few cases, but it's not inconceivable at all. I mean, remember that, you know, even the most populist and nationalist US president of recent vintage is, you know, a second-generation immigrant, you know, from Germany, right, and Scotland. So it's never far from, and, you know, but look at Barack Obama just before him, right? I mean, you know, is Barack Obama a member of the Kenyan diaspora? Well, of course he's not. I mean, we could discuss that, right? But it does raise interesting questions. And then 6 regions of the African Union. So more than institutional governance development on the international level, the African Union actually considers that the African diaspora is a pillar politically of the African Union. And so includes all those Africans and you know, descendants of Africans who no longer live on the African continent. And you know, I should mention also that a number of countries such as Ghana and Sierra Leone have now opened their borders to the broader African diaspora, allowing people to obtain citizenship on a fast track, even though they don't have a connection to Ghana specifically. So any person with Black ancestry, for example, you know, the descendants of slaves in the US, could obtain Ghanaian citizenship as part of the kind of return to Africa. Now that, you know, obviously connects to old ideas about, you know, Pan-Africanism and the the Black diaspora more generally, but interestingly point to models of political constitution and international relations, but go far beyond the state and the nation. All right, so let me move on briefly because time is flying. So why diasporas? I think if you open the scope, beyond just immigrants, right? So people will say, well, there's about 200 million immigrants in the world out of a population of 6-7 billion, which when you think of it, I mean, it's a lot of people, but it's not that many. But that's because they're talking about immigrants, so people who have a foreign citizenship in another country. If you include diasporas in the broader ethnic sense, it's much, much more. I don't actually have a number yet. I mean, I'm sure someone has produced it. But of course, the entire the whole of North America and Australia is basically diaspora based, right? In some way. Of course, the links to a place of origin in some cases may diminish very significantly through oblivion, through mixity, etc. But sometimes they maintain themselves across time. Think of a Jewish diaspora in very strong ways. So I think that's one of the reasons is we're actually talking about a lot of people whose particular legal predicament is, I think, insufficiently taken into account. The other concrete reason why I think we should be concerned and interested now is because diasporas are, and in a sense have long been, a cause of tension between states. There's objectively a kind of regulatory sovereign competition between the state of origin and the host state when it comes to the fate of these diasporas. And I gave you a few examples, right? I mean, there's right now a big tension between Australia and China that is being mediated by political debates and legal debates over the Chinese diaspora in Australia, right? So there's now a law in Australia against foreign interference, and the first people to have been prosecuted under the law are dual Chinese Australian or Australian citizens of Chinese origins, right? So they get caught in the crosshairs. And, we've had many examples of this in the past. I mean, for example, a lot of victims of McCarthyism in the 1950s in the US were members of a Eastern European Jewish diaspora, right? And who had these kinds of connections. And then a third reason why I think we should pay attention to diasporas is a more theoretical reason, which is, apart from being concerned with diaspora's fate, I think thinking through and with diasporas is a particularly powerful way to question some of the limitations of prevailing concept of international law, but also of law more generally. And I'll go on to show ways in which that is the case. But it won't be a surprise to anyone that the dominant concept of law remains very wedded to a notion that law operates within a state, that is on a certain delimited territory, over a particular identifiable national population, and as a result of the exercise of sovereignty by the state. That's our classic monist conception of the law. And as you know, international law doesn't particularly challenge that picture. International law just says, well, we're going to deal with a relations between these monist entities, and the concept of international law is, in a sense, fundamentally shaped by the parallel understanding of domestic law. And I think, diasporas come in here, and they're the kind of the bull in the china shop, right? They really escape, elude, challenge these categories. Very briefly, I mean, I think, under international law or domestic law, diasporas have been invisible. Invisibility is really a thing here, and it's interesting to question its sources very briefly. So, the dominant framework says, well, you're either a citizen or an alien, right? So most of the law is based on these kinds of antinomies. If you're a citizen, that's all there is to it, right? We don't care, especially in multicultural society, or at least we like to say that we don't care, that you're a citizen who also happens to have this or that diasporic origin, right? If you're a citizen of the US, legally, that's all that matters. The fact that you're Italian American or Irish American or Indian American is really irrelevant, right? If you're not a citizen, you're a foreigner. But that you then get lumped up into that broad category of the alien, of the foreigner. And again, we're not really interested for the purposes, let's say, of Canadian law, whether you're coming from this or that diaspora, right? That's kind of irrelevant. And the same thing goes for the country of origin, right? You're either a citizen or no longer a citizen. And until recently, I mean, that was really all there was to it. The second reason why diasporas are fairly invisible is they're extraterritorial. In French, we have a proverb, I think maybe it exists in English as well, loin des yeux, loin du cœur. Far from the eyes, far from the heart. So things that are far, that are distant, you kind of pay a little less attention to them, right? And so, of course, the state attention is kind of monopolized by what is being given guardianship over traditionally, which is the population on its territory. And historically, states were not very sentimental about their populations that left. It's like, good riddance, right? I mean, you do what you want, right? But I don't know, Italy in the 19th century or Ireland were not particularly concerned with their folks sort of moving to the US. That was that, they just left. They were no longer our responsibility. And so even if states of origin wanted to do more, they're limited in what they can do because they don't have jurisdiction in the foreign state, right? So the law makes it very difficult for them to assert power, governance, protection over their nationals abroad. There was always a kind of secondary. And then the last reason why they're invisible is they're not subject. And in international law, we're really trained to think that you're either a subject of international law or you're nothing, right? And so what's the subject of international law? It's states, maybe international organizations, individuals in a very limited way, I would say. I mean, as obviously recipients of rights, but also potentially as international criminals. But diasporas kind of really, they're sort of this intermediate subject, right? They're a bit like people without a state. We don't really have a vocabulary to describe them. They're diffused. They're not even organized like, armed groups. At least armed groups, have a kind of institutional organization. Diasporas, I mean, think of the Indian diaspora. It's extremely diverse, right? I mean, the US, the UK and Australia, but also the Caribbean, the legacies of indentured labor in East Africa and other places. So, extremely hard for lawyers to work their minds around. So one of the ideas we suggest in the book is, look, what really characterizes diasporas is they're in between. And the law is very bad at anything but in between. But the law is about the state and its population, and everything else kind of falls through the cracks. So, immigration and refugee law, for example, is really only interested in the point of entry, like the moment when you enter another country. Obviously, that's important. It's certainly important for the host state. In the broader history of diasporas, the point of entry is really not that defining or important, right? So if you're a member of the, Chinese diaspora in the US, for example, and your great-great-great-grandparents came, maybe to build the railway or as economic immigrants, etc. That's not the most important thing about your diasporic life. It happened centuries ago. Who cares, right? So immigration is not really the relevant category. What we're interested in is what we call the long tail of immigration. The fact that immigration continues to have effect down several generations, right? It ripples through time to produce legal effect that has very little to do with that initial moment of entry. There's also a lot of emphasis in the literature on integration, right? The politics of integration in a host state. And here the idea of integration is typically, although less so in multicultural societies, but you become less of a diaspora, right? Your vocation is to become part of a country, right? You're going to become first and foremost a British subject, right? Not a subject of India. And there's a lot of pressure to integrate, increasingly so. But that takes us away. I mean, really fascinating debate. But that takes us away, I think, from an emphasis to the exact opposite of attention to the continuity of links to the country of origin. And you know, another reason I think, or problem in the diasporic predicament is the notion that diasporas are a threat. I won't go into that, but they're kind of, you know, political threats. They are easily portrayed as a threat, or say, you know, there's the old kind of anti-Semitic canard, right? That the Jews have sort of dual allegiance, right? And that was used against them historically. But also, I think diasporas, I would go as far as to say, a kind of epistemic threat. An epistemic threat on the notion of a kind of state monopoly over the destiny of certain you know, populations on its territory. All right, so you know, I realize I'm running out of time, so I'm going to accelerate a little here. In the book, in the chapter, in what I have yet to produce, we do look at some people who paid attention to these things. We acknowledge their our debt to them. It's some really interesting work. We think it's still a bit limited. It hasn't fully taken this as far as one could. We also look at other disciplines, so it won't surprise you, but lawyers is often the last one to catch on to these trends. So people have been talking about diasporas, you know, there's a whole booming field of diasporic studies for decades, but in sociology and international relations and political science, but much less so in law. And we, you know, what we notice is a lot of disciplines or sub-disciplines have looked at diasporas, but from their particular angle, right? Constitutional lawyers have looked at diasporas a bit, and, you know, private lawyers and people interested in citizenship, but no one has really tried to sort of reconstitute diasporas as a legal object and subject, not starting from a particular discipline, but starting from the diasporic predicament. So one of the things we'll do in the chapter is we look at the way in which in international law, there's been all kinds of ways in which diasporas have been on the radar, but never in ways that fully account for the richness of a diasporic phenomenon, right? So we're always missing something. It's either stuck in old imperialist patterns, it's too focused on minorities, national minorities, and not enough on the connection to a state of origin, etc., or too individualistic, as in private international law or international human rights law. So our contention is we need to go back to basics theoretically, and in a sense we need a paradigm that is suited to the study of our objects, right? And that's, you know, I teach legal research methodology here at McGill, and one of my, you know, big pieces of advocacy with the students is you need the theoretical tools that work for your object, okay? And, you know, not all these tools are alike, and some tools are really problematic for what you want to study. So the question is, if we want to study diaspora seriously as lawyers, what kind of tools do we need? And our sense is you know, I say this in jest, but we need to reclaim Jessup a bit. So Jessup is a famous US judge and scholar who first coined the idea of transnational law as phenomena across borders includes all law which regulates actions or events that transcend national frontiers. Both public and private international law are included, as are other rules which do not wholly fit into such standard categories. See, that's me putting myself very immodestly next to this intellectual giant. I'll move myself down. That seems a bit more adequate. Anyhow, so but the idea was to show you that, you know, it's all about concentric circles. Transnational kind of overlaps with the public and the private, the domestic and the foreign, and it kind of dissolves. I think it gives a really useful name to our intuition that there's a lot that escapes public international law, and there's a lot that escapes private international law, and we need to get much better at giving these things names. Yeah, I think transnational law is useful. The only problem is transnational law has been kind of a bit hijacked by people who work on transnational regulation. There's a lot on the new Lex Mercatoria. There's a lot on transnational networks of governance. And still, the feeling is very institutional, very a bit bureaucratic and expert-oriented, what I call elite transnational law. And I think it's interesting to think of diasporas as working from a slightly different angle. I mean, diasporas are not primarily sort of traditional regulators, right? So diasporas don't, first, they have relatively little interaction between each other. You know, diasporas tend to be mostly lost in a connection with their state of origin. And I don't think diaspora members wake up in the morning thinking, how are we going to regulate ourselves under, you know, transnational law? I think it's more subtle than that, right? They are producing law through myriad everyday actions and through their interaction with the law. A very different conception of producing law, right? It's not that you promulgate law from the place of sovereignty, but it's that you shape, constitute the law, you know, possibly by acting as a kind of irritant on the margins of state-dominated law. And so I'm going to finish in about 2 minutes. We suggest a kind of critical legal pluralist framework based on Ron McDonald's work. Ron was a much regretted former colleague at McGill, who made this argument very strongly, right? But legal pluralism, you know about legal pluralism, right? The coexistence of legal orders within, you know, particular systems is also constantly the result of actor strategies and kind of bottom-up law production. I use the currency analogy, you know, I don't know if it makes sense, but very briefly, we know that central banks, for example, the state has a monopoly on printing money, right? So that's one way of thinking of the law. The state has a monopoly on producing the law. But we also know economically that it's economic agents that are constantly creating money, right? The state is basically printing it, but based on the underlying activity of millions of economic agents. So if there's more demand and more economic activity, the population needs more money printed, right? It's monetary policy. But ultimately, what gives the impulse for how much money is produced and when and why is economic agents, not the state. The state just seeks to sort of, you know, follow, in a sense, decisions that are being made on a microeconomic basis all the time. That's a very different concept of the law, right? We, as individuals, we have demands, but we all for law, but we also supply law. And final, I know it's we're running out of time. A very final idea is the kind of triangular model. So this is, look, I mean, other people have done this or tried to do this in other disciplines. We get inspiration from international relations, but our sense is if you want to have a serious, legally pluralistic approach to law production by diasporas, you need a kind of triangular model. And the triangle is there's the diaspora in one corner, the home state, the state of origin, and the host state. And it's really a triangle, and you know, it's a bit like love triangles. They never end very well. They're sort of very problematic. And why are love triangles, or why is having 3 children sometimes complicated? Because there's always the possibility that 2 will gang up on 1, right? Is the basic idea. You're always creating the possibility for alliances between the 2 against the 1. So I won't go into any detail. We can discuss this in a minute, but you get the sense, right? The diasporas can play each state against the other, but the 2 states can sort of do a kind of unholy alliance to regulate a diaspora. The diaspora is making demands on both the home state and the host state, and there's a kind of push and pull, you know, like all regulation. It's like, please regulate me, please don't regulate me, right? You want to keep, I mean, these are all interest-driven actors, right? And value-driven actors, etc. So they're trying to make the most of their legal predicament, such as it is, which is, you know, being a member of the diaspora is a privilege. In a sense, you have 2 sovereigns to choose from, right? It's, you know, it's a bit like having divorced parents. You've got 2 households. You can sort of play one against the other. You can say, yeah, but, you know, the rules are different with dad or mom. but it also has its vulnerabilities. You can also be caught, living in a state where you are not a citizen and have limited rights, and beyond the reach of the state that might be able to protect you in certain circumstances. With that, I conclude my presentation. Thank you for your patience, and look forward to our discussion.
Thank you, Professor Mégret, for your excellent presentation. We have several questions. The first one is on the diaspora and the potential of friction in international sphere and in international law. I think in your presentation, you have briefly covered this. So could you elaborate on that, please? Thank you.
Yeah, I mean, I could give you, I think it's always good to just use examples. I'll give you one that I wrote on because I'm, myself, I suppose, a member of the diaspora. I mean, it's a bit complicated in every personal narrative and is always complicated. The question, where are you from, is one of the most socially loaded and complicated questions for a lot of people. It's like, well, it's complicated. So a few years ago, the French government, belatedly reacted to the fact that, there's quite a big French diaspora. There's, about 1 million people who live outside France. So they decided to woo the diaspora. You know this from, what Mexico and India have been doing for years, right? And it's a constitutive move. You tell the diaspora, we know you, we see you, right? We know who you are. We're going to give you rights, etc. And so one of the things that the French government did is it allowed French citizens abroad to vote in various ways for presidential elections, for legislative elections. And that's a big chapter we have on elections and representation. Very complicated, very rich, right? How do you represent the diaspora in parliament? Do they vote? Do they have their own members of parliament? Do they vote, in the last city where they lived in the country of origin, et cetera, et cetera? So anyhow, France did this, and it created electoral constituencies. Now, electoral constituencies normally in France are just little bits of France, right? So here, France had to create electoral constituencies for the diaspora. So it created 5, I think, and one of them was North America, right? So Mexico, Canada, and the US are a French electoral constituency that sends 2 members of parliament to France, okay? There's about 300,000 French nationals in these 3 countries. And the other countries didn't particularly object, but Canada, which was under conservative government at the time, objected, saying, well, you can't have a French electoral constituency in Canada because that's an interference with our sovereignty, right? It's like you're claiming that territory. So the French government said, no, we're not. It's purely symbolic, etc. But please, and there were concrete implications because the implications was, in particular, whether the Canadian government would allow France to, in places where there were a lot of French people, to basically allow elections to proceed in rented private premises because there was no space in the consulate to receive, thousands of people voting. And the Canadian government said no. It was just very stubborn. And so lawyers were involved. That's friction. It's not a huge friction, but it's a pretty big friction. And I mean, I could come up with many other examples, but the obvious one is Russian wars of the last 15 years premised on the idea that they are protecting members of the Russian diaspora that is being unfairly persecuted. So just to be clear, I'm not saying that all of, there's a certain discourse over diasporas that's been super positive and extolling. And, I'm well placed. I understand diasporas are fantastic. They're bridges between cultures, etc. They're part of multiculturalism. But they can be a menace, right? And so clearly, Russia's use and invocation of this diaspora has been used to launch uses of force that are fundamentally illegal under international law. So we need to, sharpen our pencils when it comes to, fighting against that as well. So these are examples of friction, and there are many others.
Thank you. The next question asks, but how does the current populist nationalistic regimes in some parts of the world have an impact on this particular area of law?
Okay, so I think there is an impact, right? So, I mean, one of the things we want to look at in the book is how diasporas are constituted, right? So diasporas do not have to exist. I mean, you could be a member objectively, I guess, of the diaspora, but not feel as if you're part of a diaspora. Like, you don't have to feel Italian American if you don't want to. If it's just, you've never been to Italy, you don't speak Italian. Yeah, your grandparents were Italian, but who cares, right? So what I mean by this is fairly subjective. Like, of course, we know that nationality is entirely constructed, right? Even race is largely socially constructed. So, so diasporas are subjectively constituted. Now, one of the ways in which they're subjectively constituted is by conditions in the host country. If the host country deploys tremendous efforts to integrate you and make you feel a citizen, regardless of your origin, then you're not going to feel diasporic for very long. That's true of a lot of places. You know, think of Argentina. People, you know, lose a sense of being diasporic very quickly. In other places, I mean, you know, think of a lot of the people who went to fight for Daesh, you know, often came from underprivileged ethnic communities, and were more likely being denied, being discriminated against, etc., to identify with an imagined homeland, etc. Right? So I think the populist movement has a tendency to push people back in the arms of their state of origin, and to lead to kind of reconfiguration of identity, but are potentially much more diasporic. Now, the other strong element is the politics of the state of origin. Again, the state of origin doesn't have to mobilize its diaspora. Some haven't, others have quite intensely, including for populist ends. I mean, I think, you know, Turkey, Lebanon, etc., examples where the diaspora has been, or India has been mobilized because of the belief that it would be politically supportive of a government in place at that time, right? So your diaspora is a kind of, you know, your hidden constituency, and if they vote, if they provide financial support, you know, for political agendas, which are sometimes populist agendas, then so much the better.
Thank you. The next question asks that, does the Khashoggi type scenario that where a particular person is a victim of his own country's action abroad, does it in any way challenge the traditional ideas of treatment of the diaspora?
Yeah, so look, I mean, I think in some ways this is a relatively new development. I mean, over the last few decades, I think, you know, a long time ago, there wasn't much that your diaspora could have done from a distance. I think we're looking at the 20th century. I mean, remember, you know, Trotsky was murdered in Mexico, right? And we had Turks murdered in Germany for their participation in the 20s, so their participation in the Armenian genocide. So, I mean, I think there are some precedents. But I think what is new maybe is, you know, a willingness by states of origin to control, discipline, regulate their diasporas. And so particularly opposition diasporas. So there's no reason to think that diasporas are necessarily supportive of the host country's, the country of origin's government, right? Think of the Cuban diaspora, right, in Miami. They're the most anti-castrist you could imagine, right? They often go further than even sort of conservative Republicans would on this kind of issue. So there's an increased motivation to control. We've seen worrying and interesting examples of this historically. And one of them was Operation Condor, where, you know, southern Latin American countries, Chile, Argentina, Uruguay, sort of ganged up together to transnationally basically repress dissidents who had sought refuge in other countries. So they would kind of exchange each other's dissidents and put them into harm's way. So I think this is a reality. I would mention also that there's a lot of digital surveillance of diasporas. The Eritrean diaspora has been the target of spyware from the government. The Chinese diaspora is being closely monitored, particularly Chinese diaspora media, all from Beijing through, carefully organized propaganda operations. So yeah, you could say that. I mean, diasporas are a threat. Governments in exile are a threat, and now what's interesting is this raises a question for the host state. What are the obligations of the host state to protect members of diasporas on its territory, right? What should France do to protect Sri Lankan, people who are being harassed by the LTTE? What should Turkey do to make sure that Saudi Arabia doesn't abuse its consular privileges to murder people, on those premises? And that's really interesting because it raises the unusual legal obligations, right? They are obligations on your territory to protect people who may be your nationals or not, it doesn't really matter, from a third state, right? It includes threats to life, but threats to freedom of expression, threats to, all kinds of things.
Thank you for that answer. We are already out of time, but I'll just take the opportunity to ask one last question. It's on this idea of the triangle that you have used. So could you elaborate the interaction between the three actors in that triangle? Thank you.
Sure. Look, so I think it's most interesting to start from the diaspora. What does the diaspora want? I always return to this. Like, I'm interested in actors, and I think we pay too much attention to states, not enough attention to socio-legal actors. So simply because diasporas are not subjects of international law or domestic law as such, do not mean they're not actors. So I think there's, as I said, a kind of push and shove, right? So, and it goes both ways. So with a host state, you want all the rights of citizenship, right? You want, on the one hand, to be treated like any citizen. On the other hand, ideally, you want some of your ability to continue to interact with the state of origin to be recognized, right? So if you're a Dutch, a Turkish origin, you want to have your rights under Dutch law. You want to be a recipient, to do whatever it is that Dutch people can do. You also want to be able to go and listen to your ancestral, homeland political representatives in a political rally in Rotterdam. So you want to have it both ways, right? You don't want the host state to prevent you from continuing to have these activities. That includes, ideally, maybe you want the host state to facilitate things. So one example would be the portability of social rights. Let's say you've lived in Belgium all your life, you decide to retire in Morocco. If the Belgian law now says you lose your pension rights if you live more than 6 months outside Belgium a year, then you're not going to be happy. You want to have it both ways. You want to be able to go back and forth. So very concrete, very practical issues, right? With the state of origin, well, you want the state of origin to not unduly interfere with your lives by, killing you or your relatives. You don't want them to put pressure on your relatives back home, but you also want the state of origin to be by your side when you need protection, to exercise consular protection when you need it in the host country, to militate for you in bilateral talks with the host country, which happens. When the Indian Prime Minister has a bilateral meeting with the British Prime Minister, they talk a lot about British Indian affairs and relations and commercial contracts, etc. But the topic of the Indian diaspora in the UK may come up, right? This is just one example among many, right? So it's a common concern. And so vis-a-vis the state of origin, the other thing that the diaspora wants is kind of recognition. So you see this again very clearly, for example, with the Indian diaspora and the overseas Indian status, right? And its various instantiations. And what a lot of diasporas have done, initially it was states of origin that courted them. largely for economic reasons, in order to get increased remittances and encourage them to invest in the old country, right? Now, after a while, diasporas say, yeah, sure, no, we're happy to, buy, Indian bonds and, help India. But you know what? We want something in exchange. I mean, it's classic, political dynamic. No taxation without representation, if you wish. No solidarity without some kind of growth. So we want to be able to reside. We want to be able to buy land. We want to be able to vote. We want to be able to stand for office. We want to get, recognition. So, it's like, don't harm us, but it goes beyond that. Help us in the home state and possibly grant us access to home country politics and economy, etc. So it's a very rich kind of constant handling process, right? And the law, I mean, we know this as lawyers. We're kind of in the backseat as lawyers, right? The law doesn't create the world. The law responds to a world that is being created before it. So a lot of this is about economics and politics. But at some point, someone is going to come knocking at your door as a lawyer and solicit your advice on, okay, I want to create. Let me give you an example. So the state of origin says, hey, I think it would be really nice if my diaspora could vote. But I don't want them to decide elections from abroad because, if you're the Armenian or Lebanese diaspora, there's more people living abroad than living in the country. So if they start all voting, they're free riders. So the one argument is they're going to decide elections even though they don't live there. So constitutionally, that's a problem, right? How do you deal with that? Like, do you give them, a tenth of a vote each? Do you have them vote for separate representatives? Do you not enfranchise them at all? But then, they might be unhappy with that. So this is constitutional engineering, it's constitutional architecture, and it's all about diasporas. So, whilst the role of lawyers is not at the forefront, it's certainly important, and it is certainly not neutral in that it's all about values, principles, and the kind of world that we articulate through our legal advice, in companionship with diasporas.
Thank you for that answer. Thank you once again for your excellent presentation. I look forward to reading your book, and I hope many in the audience are also eagerly waiting for that book. Thank you so much for your time once again. Have a good day.
Thank you very much. Thank you. Have a good day, Dakar. I hope to see you in person one day.
Hopefully.